Greetings and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments like New York to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing a report in the esteemed National Law Review written by New York attorney Dean Roberts of the firm Norris McLaughlin, entitled Pied-à-Terre Tax Law, which, if you have been following our many earlier presentations on this topic on Legal Bites, you know to be a very contentious and timely topic, not just for the uber rich, but for the middle classes as well. I will then conclude by explaining how business owners can use New York law to their advantage to relocate their existing LLC or corporation out of New York to a new state the right way, while keeping their existing federal employer identification number, contracts, bank accounts, track record, and credit history intact. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 12 professional licenses and certifications spanning accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. Now on to business. On May 28, 2026, New York Governor Kathy Hochul signed the so-called Pied-à-Terre tax law as part of the New York state budget for 2026 and 2027, and it took effect on July 1st, 2026. As you may know, the law places an annual surcharge on residential property in New York City that is not the owner's primary residence and that the city classifies as a second luxury home. The state projects $500 million in annual incremental revenue aimed at a New York City budget deficit of $5.4 billion, hardly a drop in the bucket. The reach of the law is worth reviewing in some detail. A property owner falls within the new law if that owner holds 2 or more residences, one of them outside of New York City, holds a New York City residence with a market value of above $5 million, and occupies that New York City residence for 183 days or fewer during the tax year. Cooperative shares count as real property under the statute, so shareholders in cooperative buildings are captured alongside owners of condominiums and houses. Read those conditions in the law carefully, because the second and third of those conditions describe a person who may have already left the state. The tax applies to someone who lives somewhere else and keeps an apartment in the city. New York is not taxing residents. It may, in many cases, be taxing former residents who keep a foothold, and it is charging them for the mere privilege of visiting from time to time. The administration of the new law has already proven intractable. The New York City Department of Finance released a tax roll in the form of a publicly searchable database containing the owners' addresses and assessed values of more than 900,000 residential properties. 3 property owners whose primary residences were incorrectly flagged as second homes filed suit, and on August 10th, Justice Wayne Otzi of the Staten Island Supreme Court temporarily halted the rollout. Roughly 17,000 notices had already gone out by that date. Those notices demand a filing to either pay the tax or claim an exemption by September 18th. A hearing is set for August 31st, and the pause is expected to lift once the department corrects the disclosure problem. The evaluation method is its own Pandora's box and compounds the difficulty for cooperative shareholders. The city calculates the value of a unit by taking the number of shares allocated to that unit, dividing it by the total shares issued by the cooperative corporation, and multiplying by the building's overall assessed value. For my real estate attorney friends, you can already see the problems here. The notices do not explain the arithmetic or supply the figures needed to check the validity. A shareholder who wants to verify the number must go to the cooperative corporation or its managing agent for the total share count, including shares assigned to common areas and roof rights. If this sounds complicated, it is. The city expects to issue bills before January 2027. Compare this against other states like Florida and Texas, to name two, where no personal income tax exists and certainly no comparable surcharge applies to second or more homes. Neither Florida nor Texas have built a revenue plan around residents who spend part of the year elsewhere. Neither have assembled a public list of who owns what and how much it is worth outside of the normal property tax rolls. And we could spend a whole series on how those valuations are not necessarily accurate. All of that to say, Florida and Texas are in every respect favorable as compared with New York, especially given this trajectory if you are a small or medium-sized business owner. There is a broader signal here for anyone who runs a business in a high tax jurisdiction like New York. When a government faces a $5 billion shortfall due to its own incompetence, it searches for taxpayers with limited political recourse, and part-time residents are the low-hanging fruit and often the easiest target attainable. That is because property is fixed and cannot be easily moved. But if you are a business owner, your company certainly can be, regardless of what you may have heard elsewhere. Anyone who has received a notice should speak with counsel and gather proof of residency, ownership records, and occupancy documentation before responding to the Department of Finance. Do not attempt to handle that on your own. Now, with this context in mind, redomestication is the lesser known legal process of transferring a company's legal state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax repercussions, but only when performed within the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. And yes, New York allows redomestication. I will come to that shortly. I know some people are listening to this right now and they're furious because that's not what somebody told them on Reddit, or that's not what they learned practicing law 300 years ago. Well, we'll come to that in a moment. I'm getting ahead of myself. When performed by a competent professional, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. And that is to say, there is zero operational or financial disruption, but only if you get this right the first time. That is why it is imperative to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states. Yes, that includes New York, and for limited liability companies, partnerships, Subchapter S entities, and Subchapter C corporations. So if someone is telling you it cannot be done, what they are really telling you is that they do not know how to do it. Now, foreign entity registration is not the same thing as redomestication, because foreign entity registration, also referred to as foreign qualification among a miasma of other somewhat misleading terms, does not change the company's domicile. In fact, it does the opposite. By keeping the entity in the former state indefinitely, New York in our example, and merely adding yet another layer of compliance and tax obligations in the destination jurisdiction, thereby leaving you anchored to the very state you were trying to leave. Meanwhile, a traditional merger, which is still not the same thing as redomestication, creates a new distinct entity in the destination state, may and often does require the issuance of a new federal employer identification number, and can trigger serious tax complexities. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. Dissolution is the legal equivalent of the death penalty. Dissolution is a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event, and to add insult to injury, can expose the owners of the company to unlimited personal, yes, you heard me correctly, personal, joint, and several liability for the company's liabilities, known and unknown. That is because the so-called veil of liability protection no longer exists because the company no longer exists. If you think dissolution is a cost-saving mechanism, you are in for a rude awakening. And if you have a so-called professional suggesting dissolution as a relocation strategy, please seek better advice before you make a mistake you cannot undo. Redomestication, when paired with a change of personal residency and that is a very important a reduction or outright cessation of business operations in the former state can reduce or even eliminate state tax exposure there for the entity and its owners. Don't take my word for it, ask your CPA. And if you get a blank stare from your CPA, well, it might be time for a change. Now is the time to consider acting before the legislature in Albany considers changes to New York law to hinder or even eliminate the avenue of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of New York or out of another state, please utilize the link in the description or in the bio for more information on this process and to schedule time for you and I to speak one-on-one about your specific scenario. Again, my name is Chad Daniel Cummings of the firm Cummings and Cummings Law, and I hope that you found this information informative. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on this controversial and timely topic, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.